Okay, we're doing CPLR 306, which is proof of service. There are 4 questions in the quizzer book. The main take from 306B, and this is under 306 proof of service, is the addition of the description of the person to whom it was delivered. So I'm going to point that out. And I'm gonna read the whole thing, but I want to point that out. So I'm going to point that out. There's reference to 308. Okay, which is service on a natural person. You can reference that, video's up with along with the 320. I break down 308. Then there's questions, and it says 306A, but it's really 306A and B. So 306A is index number in an action or proceeding commenced in Supreme or County Court, and that is basically talking about filing and the fees for the index number. There's a 30-day if the fee is not paid. I'll get more into that. I'm just doing an overview. 306B, that last question, is a combination of 306A and 306B. We're going to get into the quizzers after this. Service of the summons and complaint, summons with notice, third-party summons and complaint, or petition with a notice or petition or order to show cause. The other ones, I haven't gotten into them yet because there were no questions in the quizzers about them. So I'm just going to attack this first because this one is a beast. Okay, so let's read. 306 CPLR. Generally, proof of service shall specify the paper served, the person who was served, and the date, time, address, or in the event there is no address, place and manner of service, and set forth facts showing that the service was made by an authorized person and in an authorized manner. Okay, B is the one that the question is going to address. And this is a case of knowing that 306 is related to something specific and particular. And that's why it's so important to understand what the titles of each section are and what is specific to that section. Because remember, all of Article 3 is about jurisdiction and proof of service. So there's different, it encounters like who you're serving, New York City, like all these various specifications. So it's really important to know that in 306, the specification is in 306B. Personal service, whenever service is made pursuant to this article by delivery of the summons to an individual, proof of service, here it is, shall also include, again, this is 306 subdivision B, in addition to any other requirement, here it is, a description of the person to whom it was so delivered, including but not limited to sex, color of skin, hair color, approximate age, approximate weight, and height, and other identifying features. Okay, so that's what we're going to encounter when we get to that question. You're going to see it. Okay. C, other service. Now here's a reference to 308, CPLR 308. Other service, where service is made pursuant to subdivision 4 of section 308 of this chapter. Proof of service shall also specify the dates, addresses, and the times of attempted service pursuant to subdivisions 1, 2, or 3 of such section. D, form. Proof of service shall be in the form of a certificate. If the service is made by a sheriff or other authorized public officer, in the form of an affidavit, if made by any other person, or in the form of a signed acknowledgement of receipt of a summons and complaint, or summons and notice or notice of petition as provided for in section 312A of this article. I believe it's, yes, sir, personal service by mail. Okay, so we're going to do that later. But just know that it's referencing, form is referencing Article 312A, which deals with mail service, okay? E, admission of service, a writing admitting service by the person to be served is adequate proof of service. Okay, let's go to 306A, which is index number. You want to remember for this 306A 30 days if the fee is not paid. Okay, index number in an action or proceeding commenced in Supreme or County Court. A, upon filing the summons and complaint, summons with notice or petition in an action or proceeding commenced in Supreme or County Court with the clerk of the county, an index number shall be assigned, and the fee required by subdivision A of section 8018 of this chapter shall be paid upon the filing of a summons and complaint against a person not already a party as permitted under section 1007 or rule 1011 of this chapter. The fee required by subdivision A of section 8018 of this chapter shall be paid, but a separate index number shall not be assigned. That's for, I believe, third party. Okay, B, here we're going to talk about the fee. If a person other than the plaintiff or third party plaintiff who served the summons or third party summons obtains the index number, so someone else is getting the index number, and pays the fee, therefore, the clerk shall issue an order directing the plaintiff or the third party to pay such person the amount of the fee paid. So in other words, I guess if they have someone that's serving it and they're paying the fee, they want to make sure that person's getting reimbursed. So they're going to notify the plaintiff, hey, you need to pay this person that just paid for your document, okay? Now, if such fee is not paid, here it is. If the fee is not paid within 30 days to that person of service of the order with notice of entry, the person who paid the fee, in addition to any other remedies available at law, may apply to the clerk for an order dismissing the action without prejudice. Okay, this is part 2 of section 306. 306 is proof of service. This is 306B that we're going to be doing. 306B, service of the summons and complaint. Summons with notice, third party summons and complaint, or petition with a notice of petition or order to show cause. Service of the summons and complaint. Now, it's important to understand the order that's going on here in 306B. Recognize the order of how this is going to go down. Service of the summons, complaint, summons with notice, third party summons and complaint, or petition with a notice of petition or order to show cause shall be made, okay, within 120 days after the commencement of the action or proceeding, provided that in an action or proceeding, provided that in an action or proceeding, except a proceeding commenced under the election law, so there's an exception with the election law, where the applicable statute of limitations is 4 months or less, service shall be made not later than 15 days after the date on which the applicable statute of limitations expires. If service is not made upon a defendant within the time provided in this section, the court upon motion shall dismiss the action without prejudice as to that defendant, or upon good cause shown in the interest of justice, extend the time for service. Notice of commencement of personal injuries. Okay, this is something different. This is 306C and 306D. So what's important here, again, the proof of service, because remember, 306 is about proof of service. So the proof of service needs to be made 120 days after the commencement of the action, right? Commencement of the action is going to and filing the papers getting the index number and paying the fee, right? And then, right, so you're filing the summons and complaint first. Then that's commencing the action. You're filing the summons and complaint, you're getting the index number for the case. So this order is very, very important, okay? So you're filing the index number first. Then you have 120 days for proof of service to serve the summons and complaint, or whatever those starting papers are, to the opposing party, to the defendant, right? And then, if the service is not timely made, the defendant motions to dismiss, okay? So that's what you're gonna get out of this article, this section of Article 306B, with that service of the summons, that order. First, you go to county clerk, you file the summons and complaint and get your index number, then proof of service. Then the proof of service takes effect. You do your proof of service on the defendant. Okay, service is not in a timely manner, the defendant can then motion to dismiss without prejudice. So if service is not made upon a defendant within the time provided in this section, the court upon motion shall dismiss the action without prejudice as to that defendant, and upon good cause shown or in the interest of justice, extend the time for service.